Some viewers may find the following video disturbing. Viewer discretion is advised.
Well, hello, and welcome back to the channel, everybody. In today's video, we find ourselves in a courtroom in Arizona, in a sentencing hearing where a defendant was convicted of robbery and the theft of numerous firearms, and, he ends up trying a sovereign citizen defense of accusing the judge of treason and apparently violating the Secret Service Act, which the Sovtard knows nothing about. And guess what? It doesn't really work very well for him because he knows nothing of any of that stuff. So without further ado, let's go ahead and get this freaking S-show on the road, shall we?
Richard James Howland, CR 2024-00463. The record will reflect the presence of the defendant, who is representing himself. He has advisory counsel, Marcus Frenefrock, who's present. The record will also reflect the presence of the victim and victim representative. Any reason to delay sentencing today?
No, Your Honor.
Mr. Howland, do you believe?
Your Honor.
All right. Go ahead.
Your Honor, I have a proper motion for reconsideration I want filed today and that I request you to read prior to sentencing me. I have the original and 2 copies for the clerk of the court, and the county attorney already has his.
Okay. Hand the copy to Mr. Frenefrock.
There's the 2 copies and the original for you, Your Honor.
Okay.
The county attorney already has his.
I'll look at the original and I'll hand it to the clerk. Okay, I have read this. Essentially, in the motion for reconsideration, it looks like it's still by George Jolly Jr., whoever that is, who is still engaging in the unauthorized practice of law.
Under the Attorney General's doctrine, Your Honor. So it says in there.
Well, I'm not going to argue with you about it. He's not authorized to practice law in Arizona.
It's the private act.
Sir, you're not authorized to interrupt me when I'm speaking.
I'm sorry.
I'm going to give you plenty of time to speak. I'm explaining why I'm denying the motion. It is submitted, even though you physically submitted it, it says submitted the 6th day of October by George Jolly Jr., someone who is not authorized to represent you. That is reason enough alone to deny the motion for reconsideration. But I'm going to go ahead and address the merits behind the motion. He cites the Ballantyne's Law Dictionary. That's not an authoritative source in Arizona, but it says misprison. I think he means, misprison, a felony or treason. I'm not sure what misprison is, but there's no place in the motion where he explains what treason, how any of this is treason.
Of course he doesn't explain the definition, or at least his definition of treason, because it doesn't exactly jive with what's in the Constitution, considering that treason in the Constitution is giving aid and comfort to the enemies of the United States. And the last time somebody in this country was convicted of treason was in 1952. But of course, these softards don't understand that simple logic because they don't even bother to read the Constitution to get the basics. And they don't even bother to look up who has been charged with treason and who has been convicted of treason. Yeah, it's a simple thing to do, but they just refuse to do it.
See what all the arguments are. You're alleging that the court is somehow covering up a conspiracy by the state. But other than stating that, you don't really explain how that's happened.
On the front page, Your Honor.
It's in the front page.
Right on the front.
Do you still have a copy?
Yes, I do, Your Honor.
Okay, tell me where it is and because I'm not seeing it. Tell me how the court has committed treason by...
Treason's not on the front page.
Okay.
You said...
Tell me what's on the front page. That, how the court is, let's see.
Treason is an overact of the government getting involved, and that's by you outstepping the bounds of law. You're committing treason, as in it's a Secret Services Act, under the fact that you're violating not just me, but multiple people that this applies to.
Oh, wow, we've got a towering intellect right here. One who doesn't bother to think through any of the ideas that pops into his head. Yeah, that's not what the Secret Service Act is all about. I mean, if you actually look it up and understand that it is not about government overreach or anything like that or anything near treason, then perhaps you'd be a little bit more educated. But I guess research is not your forte, so yeah, put on the dunce cap and sit in the corner, please.
Okay. I've looked up law too in the same dictionary thing that you're talking about is a Valentine dictionary. And that's the only one we have in jail, unfortunately. So that's what we have to go off of. And if that's not proper, well, then we should have something that is proper in jail that we can go off of, that we can get the right sightings to law. Or
So
how is that to fight your case on a proper motion or anything of the sort, even your case at all?
So how is, I mean, here in this in this case, you entered a change of plea. You've sat through 2 or 3 of these today already. All of the issues involving voluntariness, making sure that people understand what the plea agreement is. You've seen me today, and I did it in your change of plea proceeding as well. And we went through several minutes of questions. I listened to them all last week. They were all there. And then you said that you were guilty. Your attorney stated the factual basis for it. I asked you, is that what happened? And you said yes. And so today we're here for sentencing. How is it treason to give you the sentence that you asked for when you entered into the change of plea?
I asked for a motion to pull the plea.
And I denied that. How is it treason to sentence you according to the plea agreement that you entered into voluntarily several weeks ago?
That's in the notice, Your Honor, as well.
That's in the notice. I don't understand.
The notice that you struck him from the record?
Well,
it's in there that they were outdated. One day they were past their deadline, and you struck that too. And you've also struck the fact that George Jolly's not to practice law under the Attorney General doctrine. He is, because it has to be a private individual, Your Honor. It can't be someone that practices law that doesn't practice law.
So
I mean, that's not how.
You are
sorry.
Whatever the private attorney general doctrine is, if there is one, you are not citing it correctly. There is no such thing. For George Jolly to represent you, to file documents for you, he has to be an attorney.
I'm filing the document, Your Honor.
Your Honor,
so
I think we've indulged Mr. Howland enough. Can we move to sentencing, please? My victims have been here for an hour and 15 minutes now.
We'll move to sentencing when I move to sentencing, Mr. Collins.
All right. I'm just asking the question.
Thank you. That's all. This does indicate you're going to, I think, send a bar complaint on Mr. Collins, which is something that you can do. You can send a complaint to the Judicial Conduct Commission, which is something you can do, but it won't get you a different judge. I'm going to sentence you today.
Your Honor,
so
I would like time to get back from the State Bar Judicial Conduct as well. They have everything. I've already been, everything that's on file that you struck, they have it all. And I'm asking for time to waive time for now as benefit of the defendant, as in the result to get those replies back so I could proceed.
So your request is denied.
Thank you, Your Honor. One of the victim's family members would like to make a statement to the court. I'd also note, Your Honor, the plea agreement does indicate that the defendant will return the 8 firearms listed in the indictment. I don't know if he intends to comply with that provision of the plea or not, but I would point that out to the court.
Okay.
Good morning. My name is Brenda Reisner. I'm the defendant's or the victim's daughter. First of all, today's message is a little bit different than the others that the court has heard from previous co-defendants. After a lengthy time, a lot of praying, I'm no longer angry, which I think is a benefit to myself, to my family. However, that does not mean that we in any way forgive what's happened, nor are we likely to ever forgive what has happened to my family? Their actions caused a lot of harm, physical, mental, and emotional. There's evidence that they were on the property many times, and there was evidence that they had intended to return to that property. There was damage done inside the house that was not only unnecessary, but it was vicious and very malicious. It seemed that they took great pleasure in destroying what they didn't take. So while those damages can somewhat be replaced or mitigated by restitution, the mental and emotional things cannot so easily be remedied. Our family will never be able to return to that home, to live there and feel safe. We never feel safe even just being there to check on the property, to do damage replacement control, that type of thing. Even the storms most recently, we had to go there to make sure that there were not damages done, and it was very difficult. So my dad has had to change his way of life. He's had to change his medical plans because he can no longer afford the medications that he was previously taking. And then after reviewing probation's recommendations, witnessing the defendant's actions here in this court, we feel like he has absolutely no remorse for his actions, even has a sense of entitlement to take whatever he wants. We feel that he's a definite danger to any previous victims and to the community in general if he were released. Based on his own recidivism rates, he exhibits that he would be a danger. He refuses to even accept accountability or responsibility for any of his actions. Therefore, we feel that he not only deserves the maximum sentence that was possible under this court's jurisdiction, but he deserves to serve all of that without any leniency or consideration granted by the CDC. Okay, that's all.
Thank you. Anything else from victim or victim representative? Anything else from the state?
Your Honor, just the restitution. We filed a request. The restitution request is $117,148.60.
$117,148.60. That's what they're requesting for restitution.
From me alone?
It would be, counsel, correct me, but I believe this would be joined in several with other defendants.
That's what the police states, Your Honor.
So it'd be joined in several. That means anyone else convicted of the same thing would also be on the hook for restitution. They would also be entitled to have a restitution hearing if they didn't agree with the amount. But you wouldn't solely be responsible unless everyone else is found not guilty. And I think some of them have already entered into, 2 or 3 have already pled guilty. I think restitution hearings are pending in those cases.
Actually, Your Honor's already signed restitution orders in 2 other cases that I'm aware of. So,
okay.
So I believe all the other co-defendants have already accepted a plea.
Okay, so yes, you would be joint in several. That means all of you would be responsible for it. Are you willing to accept the $117,148.60?
Yes, Your Honor. As in splitting, of course.
Well, and let me just make sure that you understand how this works. It's not really splitting, but it could be. It means all of you collectively and individually owe that amount. Let's say, I probably shouldn't be playing the lottery, owing that much in restitution, but let's say they win a big lottery prize and they pay it all off. And you get out of prison, then you would owe nothing in this case. Now, the co-defendant who won the lottery and paid it all off, he might go after you and say, I think he should pay at least a third of it and reimburse me for it. But that wouldn't happen in this criminal case. It'd be separate from the criminal case. Does that make sense?
Yes, Your Honor.
You're willing to accept that?
No, I'd like to have a evidence hearing.
You want a restitution hearing?
Restitution hearing, love it. Sorry, Your Honor.
Okay. Well, we can set one up.
Can I speak with my advisory council real quick?
You may.
Wasted time. So, I don't know. I don't think you want a restitution hearing. It is what it is. No, you'll have rights to appeal.
My advisory council would like to speak for me real fast, Your Honor.
I think in summary, what Mr. Howland wanted to say is that he would like to change his mind and not have a restitution. He will stipulate to that amount. And the second one is that he wants on the record that the court has ruled that that the court has denied his motion for reconsideration based upon the merits, or denied it and struck it because it's written by a non-lawyer.
Is that what you wanted to say, Mr. Howland?
Yes, Your Honor.
Is there anything else you'd like to say, sir?
Yes, Your Honor.
Go ahead.
To the victims, I'm very sorry for what happened to you.
A bullshit? A bullshit? A bullshit? A bullshit?
No, you're only sorry that you got caught. You tried this Sovtard defense thinking that it would get you out of the situation, and when that failed, now you're sorry. Yeah, pathetic.
I know I was caught on your property, but what you think I had involved in this, unfortunately, I'm very sorry, but you're wrong. But I'm willing to take responsibility for being there, and for the things that happened to you, I'm very sorry. I pray to God that every day that He enlighten your guys' hearts for what happened to you guys. I'm very, very sorry.
Mitigating factors: that the defendant did accept responsibility by entering into the plea agreement. I note, and the victim representative has pointed this out as well, even though the defendant accepted responsibility by taking the plea agreement, he has since sought to withdraw from the plea agreement, and so I think that clouds a little bit whether, to the extent he's taking responsibility. The defendant has past drug abuse, which may indicate an addiction issue that could be a mitigating factor as well. As aggravating factors, I'm going to find the presence of an accomplice. The offense was committed in consideration for the receipt of anything in a pecuniary value. That the offense caused physical, emotional, financial harm to the victim. People come after you because they think all older people are willing to be taken and to be scammed or robbed or whatever. And you will, as you get older, you'll feel that, and you'll be. And that's, this victim is over 65. I'll find that as an aggravating. There are a whole lot more ways now of ripping off older people than there have ever been in the past. And as you get older, you're going to see that personally. So
I have, Your Honor.
So together, I find that the mitigating and aggravating factors justified the agreed upon sentence in the plea agreement. So as to count 3, trafficking in stolen property in the first degree, on or between February 29, 2024 and April 12, 2024, Class 2 non-dangerous repetitive felony, be the order of this court that the defendant be sentenced to Arizona Department of Corrections for the aggravated term of 6 years with credit. I'm updating this. Probation says it should be 306 days. It was 257 days. It should be up to 306 days because you've stayed in custody since the time the sentencing was first supposed to happen.
So it's 306 days?
Yeah, it'd be 306 days. Restitution be in the amount payable to Floyd Harrington in the amount of $117,148.60 is ordered, and it'll be joint, and he'll be joint and severally liable. All payments made by the defendant will be applied to restitution first. While incarcerated at the department, restitution will be paid by withdrawals from his spendable account in an amount determined by the director of the department acting in compliance with statute. the defendant returned to the victim the 8 firearms listed in the defendant's indictment. Mr. Howland, do you know where those 8 firearms are?
No, Your Honor, I do not know where those 8 firearms are. You're going to have to talk to the one that was selling them, unfortunately. I'm sorry, Your Honor.
Yeah. I'm still ordering you to return them. Obviously, and you can't physically go get them because even if you knew where they are, because you're in custody and you're going to prison. So, but the order of the court is that you return those firearms. All of that said, you do not have the right to appeal this sentence. You do, however, have the right to file a petition for post-conviction review with this court within 90 days of today's date. If you need an attorney to help you with that, one can be appointed for you. If you need copies of transcripts or other court records or documents, those can be provided for you as well.
Ask for those right now, or would I have to ask for those then?
Are you requesting an attorney to file a petition for post-conviction relief?
Yes, Your Honor.
Office of Indigent Legal Services provide an attorney for you for a petition for post-conviction relief.
Thank you, Your Honor.
And this, ladies and gentlemen, is a good example of why you should never try the Sovtard defense in any court, because especially if you don't know the definition of treason or even the Secret Service Act, don't pretend that you know and throw that in the judge's face, because it simply won't frickin' work. So, yeah, what an idiot. And with that being said, I hope you guys enjoyed the video. Thanks for watching, and I'll see you on the next one.
This could be some groundbreaking stuff right here.
You don't want to go to jail.
For what?
You read this.
I don't have to listen to anything. Blah, 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 blah.
Dude, so there's no way I can get in, bro? Come on, I'll put you on my YouTube.
But shut up, Wesley.
You gotta put signs up, ma'am, if it's...
Are you Glenn Serio?
Who's that?